Hello viewers, welcome to my channel. I am Hasham here. So now I am going to start the second law, that is Sale of Goods Act 1930. We are doing the videos on business law. Already last so many videos I have prepared on Indian Contract Act 1872. That is the biggest act in business law. Apart from that Indian Contract Act, we have Sale of Goods Act, Companies Act, etc. So other acts I am going to cover up now. So first of all, I am going to start Sale of Goods Act 1930. Hope you have already watched the videos on Indian Contract Act. So if you have not watched the earlier videos, I suggest you to go to the playlist of my channel, select the subject Business Law. In that you will find the videos on Indian Contract Act like offer and acceptance, consideration, free consent, capacity to contract, performance of contract, discharge of contract, breach of contract. All these videos I have already prepared and it is there in the playlist. So now I am going to start the next, that is Sale of Goods Act 1930. In this video, only two topics I am going to discuss, that is what do you mean by sale according to Sale of Goods Act, and what are the essential elements of a valid contract of sale. What are the essential elements of a valid sale? So these are the two topics I am going to discuss. Now first of all, the most common type of commercial contracts. The most common type of commercial contracts are sale of goods, because a number of contracts, commercial contracts, are conducted for sale. So what is the meaning of the term sale? We are going to cover up, and the Sale of Goods Act 1930 will consider all the provisions regarding the contract of sale. So Sale of Goods Act 1930 contains the information regarding the law relating to sale of goods in India. Regarding sale of goods, all the provisions are contained in this act, Sale of Goods Act 1930. So first of all, meaning of the term contract of sale. When we can say a contract is a contract of sale. So here, definition has been given. First of all, we'll see the meaning. What is the meaning? A contract of sale refers to a contract. So contract of sale is a contract only. The seller transfers or agrees to transfer the property in the goods to the buyer for a price. Very simple, easily you can remember the wordings. So contract of sale refer to a contract in which the seller transfers or agrees to transfer the property in the goods to the buyer for a price. That's it. This is the contract of sale. Now contract of sale in general terms covers the concept of sale and agreement to sell. Two concepts are there, sale and agreement to sell. Both are covered under the definition of contract of sale. Now we'll see what is the meaning of sale and what is the meaning of agreement to sell. So two concepts, sale and agreement to sell. In case of sale, the property in goods is passed to the buyer from the seller immediately. In case of sale transaction, the property in the goods will be transferred from the seller to the buyer immediately. For example, if you go to purchase an LCD, so LED, if you go to purchase a television, you are paying the price to the shopkeeper and shopkeeper is giving you the television. That means immediately the consideration is passed, immediately the promises are completed, obligations are completed, sale is over. So when both the parties have completed their obligation, immediately it is called a sale. Whereas agreement to sell, there is only an agreement to sell between parties, which the seller would transfer the property in goods to the buyer in future or after fulfillment of some conditions. That means the seller is not transferring the property in goods immediately. The seller promises that I will transfer the property in goods at a future date or upon fulfilling certain conditions. It is called conditional sale. So this is the meaning of the term sales. Now the sale may be absolute sale or conditional sale. Absolute sale without any condition, immediately property in goods is transferred. Then conditional sale, the sale will be conducted depending on some condition. It will be future, that the transfer of property in the goods will be transferred in future. That is conditional sale. So far I have explained you about the meaning of the term sale. So simple. A sale of contract. The sale means the act where the seller will transfer the property in the goods to the buyer for a price. Either sell or agree to sell. Sale or agree to sell. The seller transfer the property in the goods to the buyer for a price. That's it. Now, essentials of a valid contract of sale. Essentials of a valid sale. What are the elements every sale must have? So essential elements are 6 elements I have specified here, one by one. First one, the parties. Second, the subject matter. Third one, consideration. Fourth, absolute or conditional. Fifth, transfer of general property. And last, essentials of a valid contract. So these are the elements, essential elements of a contract of sale, valid sale. First, the parties. A single person cannot conduct sales. 2 or more than 2 parties are required to conduct the sale. One party is called the buyer, the other party is called the seller. The seller sell or agree to sell. The buyer buy or agree to buy. That means 2 parties are there. One is the promiser, the other is the promisee. 2 parties. And both the parties must be capable to enter into a valid contract. That means both the parties should be capable to enter into a valid contract. That means both the parties should be major. Both the parties should be of sound mind. Both the parties should not be disqualified from entering into a valid contract. The parties should be competent to enter into a contract. So first one, parties have completed. 2 parties, buyer and seller. One party is the buyer, the other party is the seller. Second one is subject matter. The subject matter of the sale contract are goods. The subject matter are goods. Then what are goods specified by the Act? Sale of Goods Act has specified. What do you mean by goods? First of all, a contract of sale of goods should be made in respect of movable goods. Remember, immovable goods, Sale of Goods Act will not apply. Other acts are there. If you want to sell immovable goods, other law is there for that one. But here, the Sale of Goods Act will apply only for movable goods. Only for movable goods. As per section 2, subsection 7 of the Sale of Goods Act 1930. So section 2, subsection 7 has defined the meaning of the term goods. Then goods means every kind of movable property. This definition you have to remember. You cannot change the wordings of the definition. The goods means every kind of movable property other than actionable claims and money. So every kind of movable property, other than actionable claims and money. It includes the stocks and shares and also growing crops, grass and things attached to the land and agreed to be severed for the purpose of sale. That means anything which is attached to the land but can be severed, can be detached for the purpose of sale. All these things will be called movable property, movable goods. So again I repeat, according to section 2, subsection 7 of the Indian Sale of Goods Act 1930, goods means every kind of movable property other than actionable claims and money. It includes stock, shares, then growing crops, grass or anything attached to the land that can be severed for the purpose of sale. Then the goods may be either existing goods or future goods or contingent goods. Existing goods means the goods which are at present on hand with the help in the hands of seller, existing at the time of entering into contract. For example, if you go to purchase a washing machine, the washing machine is already there in the showroom. It is before the buyer and seller. So it is existing goods. Whereas this future goods are those goods which are to be produced. First of all, an agreement is made. Later on, goods are going to be produced that are called future goods. Example, if you go to a furniture shop and ask the furniture man, carpenter, to make a sofa set for you. You want to buy, he wants to sell, but the goods are not present existing right now. He will make the goods after you give the order. That is called future goods. And contingent goods, the goods which are conditional. That means the goods which are purchased from a foreign country and it is in transit. So we don't know whether we will receive it or not. It is uncertain because it is in the transit from one country to another country. So when we import the goods from other country, it is conditional goods. So these are the subject matter. The first essential element of a valid contract of sale is parties, at least two parties, one buyer, one seller. Secondly, the subject matter is goods. Goods means only movable goods. So according to section 2 subsection 7 of the Sale of Goods Act 1930, goods means every kind of movable property excluding other than actionable claims and money. It includes grass, growing crops or shares, stock, and anything attached to the land. It can be severed for the purpose of sale. The goods may be existing goods or future goods or contingent goods. The second completed. Now third essential element is consideration. Consideration is the amount which is paid by the buyer to the seller in terms of money. In terms of money, the price is the consideration. Price is the consideration which is paid by the buyer to the seller for the purchase of goods. So the buyer should pay the value of the goods to the seller. The buyer should pay the value of goods to the seller in terms of money. In terms of money. Then the value what buyer is paying to the seller is called the price. Is called the price. Agreement to exchange goods for other goods is not a sale. When goods are exchanged without any money, it is called barter system. Goods are exchanged for goods. So that will not come in the category of sale. Now, however, the price may be paid partly in cash and partly in kind. Not necessarily that completely consideration should be paid in price. Even if it is partly paid in money and partly in kind, that will also come under sale. So three essential elements are completed. First one, the parties. Second, subject matter. Third, consideration. Next one is absolute or conditional. The sale includes the existing sale, immediate sale or future sale. Because according to the definition of sale of goods, it includes the sale as well as agreement to sell. Agreement to sell means it's a contract of conditional. So when the seller transfers the ownership to the goods immediately, it is called absolute contract of sale or simply sale. When the seller immediately transfers the property in the goods to the buyer, that is called absolute sale of contract of sale, or simply we call it as sale. Secondly, if he agrees to transfer, not immediately he is transferring, the seller is agreeing to transfer the property in the goods at a future date or upon fulfilling some conditions. It is called conditional sale or agreement to sell. So sale and agreement to sell both will come under sale of goods. When we call sale of goods, it includes seller sells or agrees to sell. That's all. This is the next element. Next element is transfer of general property. Transfer of general property is one of the essential element of valid contract of sale. So contract of sale should be the transfer of general property. So whenever we say the ownership is transferred, that means the general property is transferred. Property is transferred means general property. Who will have general property? The actual owner will have the general property. The actual owner of the goods will have the general property. He only can be able to sell, transfer. Whereas some people will have special property. What is called special property? A person has pledged his goods to another person. So the person who got the property through pledge is having a special property. So when we say contract of sale, it is applied only to general property, not to special property. A person who is having the pledged goods are having special property, not general property. He cannot be able to sell the goods. Next, last is essential elements of a valid contract. In the last videos, when we discuss about contract Indian Contract Act, what is an effective contract, valid contract? we have seen so many elements are there, like offer, acceptance, consideration, free consent, capacity to contract, then not expressly declared to be void. All these are the essential elements of a valid contract. Those essential elements of a valid contract must be present in the contract of sale. In the contract of sale. Because contract of sale is also a contract. When it is a contract, it must have all the essentials of a valid contract: offer, acceptance, consideration, then capacity of parties, free consent. All these things should be present in the contract of sale. So this is the end of the discussion regarding meaning of sale of goods and the essential elements of a valid contract of sale. So if you are satisfied with my lecture, give a like to the video, share my channel in your group, in your friend circle, so that more students can watch the video and enhance the knowledge. Give your comments on these videos, and lastly, don't forget to subscribe my channel if you have not yet subscribed. And inshallah, we'll continue this discussion of sale of goods in the next video.